Good morning, everyone. My name is Suzanne Templin, and I coordinate the webinars for Hausmann Johnson Insurance. I would like to welcome you to today's webinar titled Family and Medical Leave Act, Beyond the Basics, presented by Bob Gregg. Today's webinar will run about 45 to 50 minutes, and after the webinar, we will have a question and answer session. If you have a question during the webinar, feel free to type it into the question feature, and Bob will address it during the Q&A portion. After the webinar is over, there will be a short survey we are hoping you can fill out for us. A note that this webinar has been certified for continuing education credits by the Society for Human Resources Management and the Human Resources Certification Institute. Details on those credits will be provided to you at the conclusion of this webinar. Also, please be aware that this webinar is being recorded and will be available for review on the webinar archives of our website. If you do not want to participate in a recorded webinar, you may want to close the application at this time. You will receive a follow-up email from us tomorrow. I would now like to introduce you to our presenter for today's webinar, Bob Gregg. Bob co-chairs the Labor and Employment Group at Boardman & Clark Law Firm in Madison, Wisconsin. Mr. Gregg has been involved in employment relations for more than 30 years. He litigates employment cases, representing employers in all areas of employment law. His main emphasis is helping employers achieve enhanced productivity. He has designed the policies of numerous employers, creating positive work environments and resolving employment problems before they generate lawsuits. Mr. Gregg has conducted more than 3,000 seminars throughout the United States and authored numerous articles on practical employment issues. He has a wealth of knowledge on this topic, and we are very thankful that he is here and he could share some of his wisdom with us today. Welcome, Bob.
Thank you. We're here today to talk about something that we call FMLA Beyond the Basics. The agenda is going to start really quickly with the basics. Excuse me. And then we're going to try, in the time that we have, to cover a variety of topics. Interrelated laws, personal liability, how much leave, what if there is no request for FMLA, combinations between the Wisconsin and the federal laws, and some of the light-duty workers' comp interactions, and a few other things, if we have the time. Let's start out with the basics. The federal FMLA covers serious health condition of the employee, serious health condition of a parent, child, spouse, including people who stand in the place of, in loco parentis. Leave for birth, adoption, foster care, placement of a child, all of you know this. Also, military exigency leave, military caregiver leave, total leave entitlement of 12 weeks in 12 months, depending on how you measure your 12 months, for all purposes, under the federal law, so it's an aggregate. Doesn't matter what you use it for, it's a grand total of 12 weeks, except for military, 26. Wisconsin, on the other hand, does not aggregate. It covers serious health condition, 2 weeks of the employee. Your family leave, 2 weeks. And then leave for birth or adoption, etc., of a child, 6 weeks. So each one of those is separate. And unlike the federal leave, does not run together. You can run state and federal leave together, and so federal leave can count as state leave and vice versa, but you have to remember that you're tracking the state leave differently until that 2 weeks, the next 2 weeks, or the 6 weeks is over. You get a grand total of 8 weeks under the state leave. And that leave can be in blocks or increments of an hour or more, or intermittent, which means here, there, and that means that the leave can stretch to either 12 weeks in a block or 12 weeks worth of hours if you take it intermittently or intermittently or incrementally. That's going to come out later as an important fact. That's the basics. And since you know those, that's not what this program is about. Let's move beyond the basics. FMLA does not operate in a vacuum. And if there is litigation over over an FMLA issue, it often is accompanied by the Americans with Disabilities Act, because most disabilities, if you take leave for them, qualify for FMLA. Title VII covers sex, including pregnancy. And so the leave for new child or the leave for the condition of pregnancy can be covered under Title VII. Not only that, it's the sex discrimination parts of Title VII interplaying with the FMLA, giving leave for fathers. There is nothing anymore called a maternity leave, because that's discriminatory. There is new child care leave, parental leave, but when we give special preferences to women, we may not only violate the FMLA, but also Title VII. Age discrimination. As we get older, we tend to take more FMLA, but the other thing that happens with age discrimination and the combination between FMLA, Title VII sex discrimination, and age discrimination is there's a great tendency in a number of cases in which employers have been very happy to give maternity leave for pregnancy or new child and just say, yeah, sure, without much hassle and without much scrutiny. Yet when an older person takes leave for themselves, there is more scrutiny and more denial, and we find out sometimes that giving leave to women for pregnancy and new children, yet not giving it to older people, generates FMLA and ADEA cases. Workers' compensation goes along with FMLA if I am taking leave. And finally, civil suits, privacy and confidentiality, because FMLA, ADA, a number of these A's require us to keep all medical information confidential. You got to keep it separately and so on. And when we breach that, we not only violate the law, but we also are invading people's privacy, and we get civil suits under the state civil suits. Defamation, sometimes when we leak that information about people's conditions, it starts the rumor mill. And so we give out a little piece of information, inadvertently breaching confidentiality, that somebody went to see a doctor about something, like went to see a psychiatrist because of their daughter's condition, but the rumor mill starts out that the employee herself had a complete and total mental breakdown and has been hospitalized and is under medication, and suddenly her reputation throughout the company and the community is destroyed, because you know how the rumor mill goes. And our breach of confidentiality that violated one law is now a defamation suit. So we have to be very careful about these, because nothing operates in a vacuum. And so often when the floodgate opens, it opens under several of these laws at once, each of which has their different liabilities, which leads us to the next one, personal liability. The FMLA, the FLSA, and a number of other laws, a growing number of other laws, impose not only corporate liability, but they allow people to sue individuals. They name you. Mary Jones, Jack Smith are named along with the company in the case. Who gets named in the cases? President of the company, human resources. The FMLA allows you to name line supervisors, the people who actually were involved. There is a growth area in personal liability. Every time Congress passes a law, it is not enough to say here's liability, but they become increasingly punitive, and they let people name individuals. They even have criminal penalties in some of them. We're not here today to talk about all of those laws, but it is important to know them. We've got an article that we didn't give you today, but if anybody wants it, drop me a line. I will be happy to send it to you. It is called, Are You in the Crosshairs? Your Personal Liability for Employment Issues. and it lists several pages of those laws that you may wish to be aware of that carry that personal liability. It might be important to let your supervisors know this, because when they say, well, why should I listen to human resources, they may have a personal stake, and when they are aware of that, they may pay more attention. The article also lists things that you can do. There are shots of immunity that will keep you safe from personal liability, so it's not just a scare article, though I do suggest if you get the article, don't read it on a Friday night before bed. It will spoil your weekend. So under the FMLA, what can you have personal liability for? Denial of leave, denial of reinstatement, unfair discipline, interference with the leave, and retaliation. There's a presumption that for a full year after I've taken FMLA, any bad thing that happens to me, discipline, transfer, denial of promotion, etc., is because of retaliation, and you've got the burden to prove that it wasn't. So there's a presumption there. Here's one of the other things about personal liability. Unlike some other laws, the FMLA does not require intentional violation of the law. It just requires you to violate the law. What is the single biggest area that supervisors find themselves named in cases? It's that issue of unfair discipline. Anytime that you are disciplining somebody for attendance, anytime that you are faulting me on my performance evaluation and taking away points from my annual bonus or whatever it is that you do with that, you cannot consider my use of protected leave. And yet the supervisors who have no clue what the FMLA covers just write out the evaluation of the discipline that says, you haven't been here enough this year to justify your existence, and they have mixed in protected leave, and they get named in the case. And then they are totally shocked because they didn't even know what FMLA was about, and suddenly they're in the middle of the case. So it is important to work with human resources. It's important for HR to educate supervisors that before they do any disciplinary action regarding attendance or performance, to carefully check with payroll and make sure that they have excised every piece of protected leave, FMLA or ADA or any other protected leave. Personal liability is scary because the damages come out of your personal assets. Your retirement fund, your children's college fund, your house. And remember, it's HR managers, CEOs, CFOs, board members, line supervisors, and it's not to be taken lightly. You know, it's not just your assets that you have to be aware of. This has a broader effect. Wisconsin is a marital property state. And so if somebody comes after your personal assets, it's not just yours, because you only own half that house. Somebody else is suffering too. Now, I sort of like marital property. It works well in a marriage. My wife will go to the refrigerator and say, didn't I have some leftover cheesecake? Marital property. I like that concept. But when you have liability, it's not nearly as nice and not nearly as funny. And so make sure that people are at least aware that they have a stake in the game. Personal liability. Let's move on to the next item. How much leave is each person entitled to? We've given you an article on that. In fact, the article on FLSA and FMLA was just published in the Wisconsin SHRM magazine, because we think 12 weeks means 40 hours a week times 12, 480 hours, and it doesn't. 12 weeks in a block means 12 weeks. I am entitled to 12 weeks worth of FMLA at my normal hours. Now, we tend to think that 12 weeks is 480 hours. max, but we also know that if somebody works a 30-hour-a-week schedule, well, they're entitled to FMLA, but we're happy to cut them back to 30 hours a week worth of FMLA, which is less than 480 hours. But how about if somebody normally works more than 40 hours a week? We often don't think, if they are taking leave incrementally, that they are entitled to a lot more. And that's where this article starts out. It says, we think they exhausted FMLA because they used 480 hours, and the employee says, oh, no, I got another 70 hours left. And you're doing the math, and you don't see more than 480, and then you've got to take a look at all the overtime they worked that year. You've got to take a look at the 6-day weeks, because if you're in sales, you don't work a 5-day week. You often work Saturday mornings or Saturday all day. How about a salaried employee? If you're a salaried employee, how many of you leave at 5 o'clock every day? How many of you take your work home and put in lots of extra hours, because those hours stack up and they create extra leave? How many of you actually keep the hours? Because the state law actually used to require us to keep the hours on all employees, including salaried, but doesn't anymore. And the federal law has never required us to keep track of the hours of a salaried exempt employee. So we don't. And then that salaried exempt employee says, well, you know, I'm entitled to a lot more than 480 hours in FMLA. And in fact, if you cut them off at only 480 hours, you've given them the notice that said, you've used all your FMLA. If you cannot be back by next week, we are able to terminate your position, and you have no reinstatement rights. And we do that, and that salaried employee is now no longer employed, and they sue us, saying, they preempted my return because they should have waited another 3 weeks before they did it, because I had X more FMLA entitlement, and they wouldn't give it to me. They're going to win, because, and we said, well, we have no idea how many hours they work. Why is it that you should keep track of the hours of a salaried exempt employee, at least the number of hours they work a week? It's because when you get into this, if you did not keep the hours, the court will take their word for it. They'll say, I worked 60 hours a week. Every week, I swear I did. And you're saying they beat the clock out the door every day. I'd be surprised if they worked more than a half-hour overtime in every quarter. Well, if you want to prove it, you should have been keeping hours. And if you didn't keep the hours, the court will take their word. Now, that doesn't mean you have to have them punch the clock like you do many hourly employees, but you can have them fill out an hourly timesheet. Say, Monday I worked so many hours, Tuesday so many, Wednesday so many, or at least this week I worked so many, and have them fill it out. That way, if you get into this bind, you've got some idea of how much FMLA they're entitled to. You know, you also have an idea, just in case you get an audit by the Department of Labor on whether they actually should have been categorized as salaried, and you lose, and they say you owe these people overtime, you've got some idea of how much overtime you do or don't. Does overtime count? Yes. If it's mandatory overtime, that counts toward my FMLA. And so if I'm a 40-hour non-exempt employee and I work mandatory overtime, then that goes into the calculation. Voluntary overtime doesn't. You say, hey, would anybody be willing to work this weekend? And they sign up for it. That does not add on to their accumulation of FMLA leave. But how do you know how much they're entitled to? You take a look back at the last year, 12 months. You take a look at the number of hours they worked that were mandatory, and then you figure out the average. And that will give you the weekly average. And that will tell you how many hours they are entitled to, because it's not just 40 hours a week anymore. They may be entitled to take FMLA at 46 hours a week, which increases it substantially. Work from home. We didn't even know they were working from home, but they've got a computer log that shows they were. The work from home counts as FMLA. If you didn't police it, if you didn't have a policy that says for hourly employees you will only work from home under the following circumstances and with permission, then that may add to the hours of FMLA entitlement. It certainly adds to the hours for eligibility. And there have been a number of cases where he said, oh, I'm sorry, you didn't work enough hours. You're a part-time employee, you did not work enough hours this year to be entitled to FMLA. And they said, oh, yeah, I did. I was working from home. And here are my computer time logs to show that I put in the extra 100 hours from home, and they're entitled to FMLA. So be careful from that work from home. Work off the clock is not necessarily off the hook for your liability and for them stacking up hours on it. So be careful before you tell people they are out of FMLA and how much they're entitled to. If they're taking it in blocks, a week is a week. But if they're taking it a little bit at a time, that can go on for a lot longer than you thought. What if the employee does not request FMLA leave? They're gone. And we sort of heard that they might be gone because of absences. Now, let's go back and say that your policy should require people to use your time and attendance reporting. Under FMLA, people are entitled to be gone, but they are also required to at least let you know. And so a no-call, no-show is still a no-call, no-show. A failure to report that I am not going to be in today is still a failure to report, unless there's some sort of dire emergency. But if people are gone and you have reason to believe that it might be for a qualifying event, they don't have to wave a magic wand and say, do anything regarding FMLA, because what the courts have said is that the average employee is not sophisticated. The average employee, even though you have given them a numerous page policy on FMLA, and you've posted all the posters on FMLA, the average employee will be confused about this. Human resources are the professionals, and human resources should be leading the employee, not sitting back and waiting for the employee to come through and do magic to get their FMLA. So there is no duty under the law for the employee to make a request for FMLA. And many people lose cases because they say, well, the employee never asked for FMLA. Did you know that they were out on sickness? Well, yeah, but they never asked for FMLA. Did you know they were in the hospital? Well, yeah, but they never asked for FMLA. Who's the professional? The welder or the human resource manager? Who should have been following up? Who should have been at least informing them of their rights? So the employer knows the details of the law and is responsible for the compliance. Down in Whitewater, Wisconsin, there was a company where the supervisor was ticked off at this employee because they weren't there a lot. And the employee's son, teenage son, called into the supervisor, because that's who you're supposed to call when you're absent, and said, Dad can't come into work today. He's in the hospital. Well, supervisor called up human resources and said, he's not here again today. Can I fire him now? Can I finally fire him? And they said, well, yeah, I guess so, if he didn't show up. Well, the supervisor, not being sophisticated and being a standard angry person, as many of us are, did not convey the hospital term Not only that, some of our policies say you must call in personally, and they won't even accept a call from the kid. Well, that resulted in the supervisor being named in the case, the HR manager being named in the case, and the company losing the litigation. Once we have knowledge that somebody has used the word medical, mental, hospital, sick, before we make a snap judgment, we need to follow up and get a little more detail. Even when somebody no call, no shows, if there's any indication that it was because of a medical issue, we need to give them the latitude to provide that information and then undo the no call, no show discipline if they can provide the medical information that they were in the hospital, unable to call, or something like that. So we have the right to enforce our policies. We don't have the right to deny FMLA simply because people were not sophisticated enough to follow our policies. So any information the leave was for a medical reason is enough to trigger the employer's duty, not the employee, the employer's duty to follow up. Failure to give notice of rights can be interference with the FMLA. And remember the 5-day notice requirement. If you find out that somebody was sick, they were in the hospital, which is an automatic qualifying event, and remember there are different qualifying events under the state and federal law, 5 days to give them notice that this might qualify for FMLA. Now, that 5-day notice is built into the law. The courts have given you some latitude. Just in case you didn't give notice in 5 days, you have not committed a major sin or result in liability, you can still give the notice at any time thereafter. However, if it was an FMLA qualifying event, you may not be able to backdate their use of FMLA completely to the time that they were in the hospital or their leave started. They may have gotten some leave that they are entitled to that you can't chalk it against their uses of FMLA, and you can't chalk it against excessive absence at the same time. So 5 days notice to let them know that they may have an FMLA right and give them the opportunity to let you know. The employer's silence or inaction can be an FMLA violation. You know that there is an interactive process under the ADA. Most of us are very keen about going through the process with the ADA and communicating and getting information, and yet under the FMLA, for things that are not disabilities, they're just the standard serious medical problems, we don't do that. And though the interactive process is not in the statute like it is under the ADA, it's still sort of there. So a lack of communication is fatal, especially a lack of communication between line supervisors and human resources. Supervisors don't need to know the intricacies. They don't need to know how to figure out the time frames. They don't have to know how to assess everything, but it's the supervisor that the teenager called and said, Dad's in the hospital. It is the supervisor that people come to and they say, hey, I'm struggling with the situation, or I'm going to need some time off. And if the supervisor does not communicate that, then things drop through the crack. So they should have at least basic understanding of how to communicate with human resources. They should know that any mention of medical or mental may be either an FMLA or an ADA issue. And so anytime they heard the word medical or mental, they should take a step back. They should tell human resources, I have this information. They should do it verbally and confidentially, because you remember that the ADA and the FMLA require confidentiality of medical information, so they should not be gossiping about it. They should not tell the work crew, hey, Jack's not going to be here next week because he's got whatever the condition is. They should not post the medical restrictions on the bulletin board. Say, hey, be aware that Jack's got all of these restrictions, so everybody make sure that you don't make him do any of this work because he's got the following diagnosis. They should keep their mouths shut about their opinions, because far too often supervisors tell an employee, oh, I'm sure that qualifies for FMLA, and it doesn't. They made a promise. Or they tell the employee, nah, I don't think that fits FMLA, and it does. And so the employee does not take off for the medical thing. The employee's rights have been violated. They have interfered with the employee's FMLA rights. Out of ignorance, they should not make any promises, and far too often supervisors just cover. They'll have a supervisor come in and say, oh, you know, I'm getting frustrated because John's been off. He's had all these medical appointments, and he's off all this time. And HR says, when did that start? Oh, 6 months ago. What have you been doing? Oh, we just have people fill in. We've been covering for them, but now it's getting to be a problem. They could have burned their entire FMLA leave, and the supervisor didn't even bother to tell the employee that they should check with human resources. The supervisor didn't bother to tell human resources this was going on. And now, only now, because it's been more than 5 days, can we start day one of FMLA, because the supervisor was just covering. So please, give your supervisors at least some rudimentary training on ADA, FMLA, and especially anytime, here's the golden rule, anytime they hear the word mental or medical, they should take a step back and inform HR. Okay, let's move on to the Wisconsin and federal FMLA leaves. Let's take a look at an example. Bill is adopting a child. He wants to take 2 weeks off before to prepare the house and to travel to the adoption city. Then he wants to take 2.5 days off each week for 12 more weeks, so he and his wife can split up care and adjustment for the new child. Can he? Well, here's where the state and the federal laws have a little bit of difference. First, the ability to take off for birth and adoption includes the right to take off for preliminary things, like to go through the adoption process, set up the house, to do some adjustments. That's covered under both the state and the federal. But then when he says, I want to take time off, let us presume the Bill's spouse does not work for you, because if they work for the same employer, you can stack a certain amount of family leave for this. But under Title VII, remember the Interrelated Laws? Bill's got the right to take time off as a father. It's not maternity leave, it is new parent leave. The Pregnancy Discrimination Act is part of the sex discrimination provisions that allows fathers time off for child care as well. Under the Federal FMLA, you get 12 weeks for everything. Remember, the state gives you a separate 6 weeks for each thing. The Wisconsin FMLA allows people to take that 6 weeks for new child anytime they want it. They can do it in increments. They can do it in dribs or drafts. They are not required. So he can take at least the Wisconsin allotment of that 6 weeks, equivalent of 6 weeks, the way he is requested to schedule it. Under the federal law, the new child leave is a little different than the medical and family leaves. The new child leave, you can deny that. And you can say you're entitled to up to 12 weeks that you can use for new child leave, but you must take it in one lump. We, as the employer, have the right to adjust your schedule for our convenience. And if it is inconvenient for us that you take the new child leave intermittently, well, then we're going to make you take it all at once, or we will dictate how much incremental leave you can take and when you can take it. So you've got a lot more control under the federal law. So let's say that he asks for this schedule and you allow it under the state law the moment that he has exhausted the equivalent of 6 weeks worth of hours. You can then say, okay, your state rights are over. Now we're going to shift to the federal law, and the rest of that leave you will be taking under our direction, not under your request. Most organizations don't do it. They just say, fine, whatever works for you. But there are a number of circumstances where it may be difficult for you to give this incremental leave for that. So be aware that you have the right, that you've got to be tracking state and federal very differently. Let's go on to federal and state in another way. You've got different locations. And the federal law says if you've got 50 employees within 75 miles, they're covered by FMLA. If you have differing locations, then around the state or around the nation, some of them may have 50 employees, some of them may have 20 employees. Are they within 50 miles? Oh, what is 50 miles? We had somebody measuring. Is it road miles or is it crow miles? And they were trying to measure road miles, and they had an entry on the back of the parking lot, and they blocked it off because if you had to go then clear around the block to go into the front entrance, it was 75 and a half miles. They made the argument. So is it road miles or is it crow miles? Generally, it is road miles, but I wouldn't go to that extreme to try to prove it. But what if you have, look, if I have remote locations, and many of us do, some of our locations are covered by FMLA, some are not. Under the state law, it's 50 employees anywhere. Anywhere, even if one is in Wisconsin, that one employee gets state FMLA. So we have operations where people are covered by state FMLA, not federal FMLA. We may have operations where people are covered by federal FMLA and state FMLA here, but you've got a place across the river that's not covered by either because it's in Iowa or some other state. So what do you do with that? Well, one of the things that you do is be aware of that, but you've got to make your employees aware of that. Unfortunately, what we do in far too many cases is we create extra liability by using one policy for all, and it doesn't fit. And what the courts have said is if you are not covered by FMLA, that you give people a policy, you've established a contract. We've got another article that is called Blundering into Liability, Generating Inadvertent Contracts That You Didn't Know You Had. You can drop me a line, I'll send you that one too. But here are cases where people have created greater liability because of their FMLA policies they've made guaranteed to non-covered people, and the courts have said, you didn't have to comply with the law, but once you gave them the guarantee, the policy, now you are liable for all of the FMLA and the damages for not following it. One of them, they gave everybody greater protections for treatment for marijuana discharges, and then they allowed it in states where marijuana was legal, but they fired people who wanted marijuana treatment in places where marijuana was not legal, but they gave the same policy nationwide under their FMLA. They were bound by it. How's this happen? I review a lot of employment handbooks, and I'll get a company that only has 35 people, and they got an FMLA policy that runs for 3 pages, and I'll say, why do you have this? Oh, well, we got our handbook actually from my cousin's company out in Kansas, and they're a big company, so they must know what they're doing. And so we just changed the names to ours and adopted it. And I said, you're not a big company. You're not in Kansas. Get rid of this, because you are giving people a guarantee of things that you're not even covered by. So make sure at least that you are covered before you give out a policy. And give out a policy that has an exclusion. And here's an example. Company locations in wherever you're not covered by FMLA are not covered by the Federal FMLA. And so just let them know, and that can be part of your FMLA policy. You can still give people reasonable rights, but if you have a disclaimer, you are not contractually bound to all of the I's and T's and dotting things that the FMLA makes you do. Okay, FMLA intersects with workers' comp and the ADA. Workers' comp says that you are entitled to a leave of absence. It doesn't give you 12 weeks. It doesn't say we have to keep your job. And in fact, if you're not back, you're done. But you are required to rehire people at some point. The FMLA gives you 12 weeks. And I put that workers' comp X at the same place because if I'm out on workers' comp, the Federal FMLA will at least guarantee for 12 weeks that you can't eliminate my position because they both run together. Disability, on the other hand, does not have a 12-week. It says reasonable leave of absence for an accommodation. If you terminate people at the 12-week mark, you have violated the ADA because you got to say it is no longer reasonable to hold this open. How long is reasonable? That's part of the interactive process. So they all run the same time because a reasonable leave of absence is burning my FMLA, even though it is an ADA leave of absence. It's a workers' comp leave at the same time. My FMLA is running then, at least my federal. Wisconsin does not allow you to use workers' comp to burn the 2 weeks of state personal FMLA. So they're off. They burn their entire 12 weeks of federal FMLA while they are off on workers' comp. But they still, if they return, they still got 2 weeks that they can use for some other illness purpose. That does not mean that that 2 weeks is allowed keeping their job forever. It just means you can't burn it while they're on workers' comp. You also have to be aware that workers' comp often gives light duty. Actually, we'll go back. Under workers' comp, I am entitled to be off because I've injured myself, and I can't do a job. FMLA means I can't do my regular job. I may still be able to have other life activities. So I have a throat operation. I can no longer be your telephone receptionist. There's nothing wrong with my arms, my legs, and my ability to get a suntan. And so you're getting upset because this person is on FMLA and they're out on the golf course. Hey, FMLA is my inability to do my regular job. I don't have to sit at home in the dark. I can go out and do life activities as long as they are not inconsistent with my serious medical condition. Workers' comp, you have the right to make them come back and do some work once their FMLA is up. They can refuse to come back. You can say, we have light duty. You can't do the telephone reception job, but we have this warehouse full of boxes, 100-pound boxes, light duty. Nothing wrong with your arms and legs. You can lift and carry. They can refuse to do that for the 12 weeks. Now you can force them to come back, but be aware If you use light duty, which is a form of accommodation for workers' comp or disability, it does not count toward FMLA. Once I am back at work doing anything, you cannot burn any more FMLA. It doesn't count anymore. Also be aware that light duty for too long may create a new job. And you said, you know, you can't ever come back to your regular job. You've been doing light duty for 6 months, but the doctor says you'll never be able to resume your regular duties, so we're going to terminate your employment. They said, oh, I can do my regular duties. You created a new regular job for me, and the courts will agree. The Wisconsin court said, putting somebody in a light duty position for 6 months, you must have needed that job or you wouldn't have let it go for 6 months. You created a new job and you cannot terminate them. So be very careful, because light duty interferes with their FMLA burning and may create a new position that you didn't know that you had. Okay. Finally, we have a manager on FMLA. She's answering questions from her staff using her phone and home computer. She left in a hurry, so there's a lot of confusion. Since she's home without anything else to do, can we expect a prompt reply? When I am on FMLA, de minimis interruptions are okay. But the moment that you start doing a lot of regular interruptions, I'm not off on leave anymore. As a salaried exempt employee, if I am doing more than de minimis, then that's a day I was working. Can you actually count it? Must you pay me? Remember, under the FMLA, you can take hourly deductions from exempt employees as if they were hourly. But once you start playing with it, you're going to have to keep careful track, and it may violate the FLSA salaried exemption rules because you're not allowing them to be off. It certainly can be seen as an interference with their right to take FMLA, because my right to take FMLA means I've got the right to be off, and off means off. Unless I voluntarily want to set up a schedule for some work and some not, those interferences can be a problem. So be careful, and have a control, because all of their employees are calling them all the time without regard to what human resources even knows about. So have a protocol that if you're going to contact people on FMLA at home for work-related issues, have a guardian and say, you got to go to Charlie. Charlie will decide whether we call so-and-so at home. Charlie will make the call. So at least have a control. And finally, remember that in retaliation, anything that happens to somebody who has taken FMLA will be presumed for the next year to be retaliatory. So once it's over, it's not over. You've got an extra duty to monitor, an extra duty to make sure that all decisions, treatments, and evaluations are valid and that you can back them up. And I think that leads us into the ability to ask some questions. We covered a bunch of stuff very quickly. This is certainly not all of the complications of FMLA, but it does illustrate some of the beyond the basics and some of the fundamental things that get people in trouble.
Well, excellent. I know that we have a bunch of questions here for Bob, so strap in. Here we go. Tiffany asked us, if we have an employee who volunteers for overtime on a Friday outside of his 40 hours but calls in because of a doctor appointment he forgot about, do we count that as FMLA, correct?
No. You got to be careful. You know, I'm a lawyer. I should have learned to say maybe. I have to go to the books and look at that. But I'm going to say no on that one, because remember I said that voluntary FMLA does not count toward increasing the person's annual allotment beyond the 480 hours if it's truly voluntary. The flip side of that is if you can't count it, if it doesn't add, it also doesn't subtract. So you get the advantage that a voluntary overtime does not create an extra burden for the company to give more FMLA, but you can't then turn around and say, well, it's voluntary overtime. If you didn't show for it, we're going to subtract your FMLA. It's voluntary, and voluntary is voluntary. If it's mandatory overtime, which does add to their annual allotment, you can also use their absence in that to take away from their annual allotment as well.
Cheryl asked, my employee refused to complete the FMLA forms, saying that they are going to take vacation for the 4 weeks they need off for a surgery. What can I say to the employee to get the information needed?
And, I made a big point of the fact that we need to, you can lead people to water, but you can't, and you can give them information, and you give them the notices, and you give them extra letters that say, hey, here's what we want, and if you don't fill this out, it will not count toward FMLA, etc. But once you've done that, it may be impossible to make them fill out the forms. Now, I'm going to start with that. And if they don't fill out the forms with proper notice of the consequences, then you can give them the consequences, which is this will not count, this will not be protected by FMLA. And there's a real good case on where they did exactly that. The person went off on their leave, and during that time, the company decided to replace their position, and they sued, and they said, hey, I was off for medical reasons. And the court said, you didn't complete the FMLA, you knew you had the entitlement, you chose not to take a protected leave, therefore it was not a protected leave, and if they chose to replace you, that's your problem. Here's the other answer. You have the right, under the federal law, to force them to burn FMLA whether they want to or not. And there are many people that say, I don't want to burn FMLA for this. You also have the right to force them to burn their vacation. There are people who say, I want FMLA, but I don't want to use my vacation. I want to use it when I'm well. And if your policy gives them the information that it is the company's decision, then you can force the burning of that, and you can say, we have knowledge that this is FMLA, and we are going to count it against your FMLA. If you don't like it, you must present us information that contradicts what we're going to do. Otherwise, we're burning your FMLA or we're burning your vacation. Now, under state law, Wisconsin says they have the right for that first couple of weeks to elect to save their vacation time. Then you can burn it after the first 2 weeks. Under the federal, it's a little complicated, but you have a little more control here. If they say, no, I don't want to use it, you may be able to go ahead and say, well, we're going to count it toward that anyway. Before you do, I would consult your attorney on that one, just to make sure that you're on a sound basis and that you give them the appropriate notice.
Donna has posed a scenario. Joe employee qualifies for intermittent FMLA for Condition A. He takes 80 hours of FMLA time over the course of 6 weeks. A week later, he finds out that he has Condition B and needs to take intermittent FMLA for that condition as well. In order to do this, must he, A, have performed 1,250 hours of work in the time leading immediately up to that need for FMLA for Condition B? B, will the available FMLA time for Condition B be reduced by what he has already taken for Condition A? And that's it. There's a lot there.
Okay. Well, let's start out as, if it's in Wisconsin, remember that the Wisconsin law kicks in at less hours. And so people may be qualified for Wisconsin law, but not for the federal law. So you got to remember that. Also, are you measuring the FMLA on a rolling horizon, like the 12 months prior to the taking of FMLA, or are you measuring that on a annual basis? State of Wisconsin law is always measured on an annual basis, so every January I get my 2 weeks, 2 weeks, and 8 weeks back. But the federal law, you have the ability. If it's on a calendar basis, well, then he earned it when you started January again. The answer is, if it's a new condition, once I qualify for FMLA for a condition, then I get my 12 weeks for that condition. If it's a new condition, you may well be able to measure backwards from that time. If you have given him 12 weeks that he is already entitled to for the old condition and he's using it, and he would still be able to use it for that new condition before you say that you can't use it for condition B, that's one that I will say that I need to go to the books on and take a careful look before I could give you a definite yes or no.
Susan asks, if we have one employee in another state, is that person covered by Wisconsin FMLA?
No.
Okay.
And they may not be, if you have, now, if you have one person in another state, they may not be covered by any FMLA, unless, of course, you happen to be right on the Mississippi River, or right on the, they're in South Beloit, and you're in North Beloit, and you got 50 people in one of them and only one in the other, they're still in 75 miles for federal. But no, Wisconsin FMLA covers only those people who are working in Wisconsin.
Nicole asked, what if you have informed an employee of their rights under FMLA, they have received the paperwork to request a leave, but have not returned anything for us to determine if it falls under FMLA as a qualifying reason. They continue to call in. Can we discipline them, or do we need to assume it is a qualifying purpose and count these hours towards FMLA?
I would start, you gave them the notice, so you can start chalking those hours up, sort of in a bank for when they do reply. Remember that you have to give them at least 15 days to give you that notice, to respond to the notice to let you know that it qualifies before you can then send them a denial. If they don't give you the information within the 15 days, then you should fill out, there's a bunch of little forms. And so they can fill out a denial form. You can fill out the denial. We're not giving you FMLA. Here's why. Because you didn't give us any information. You now have time to cure before we actually say this is uncovered leave. It doesn't count, you're fired for unauthorized leave, or whatever you do for that leave. But make sure you go through the forms process. My tendency is to give a little more latitude than the law actually requires, so you're on the safe side. Remember, you will be judged by a jury. This is a golden principle that I put into almost every program I do. You will be judged by a jury on how fairly and considerately you treat those people who irritate you. You will be judged by a jury on how fairly and considerately you give latitude to those people who are obstinate and don't cooperate. So give them a little more, but remember the forms will guide you through it. 15 days at least to respond, and then give them the denial notice, and that denial notice will say, if you don't like this, here are the consequences, and promptly let us know.
Okay, we have time for one last question. Anne asks, can you hand out the FMLA notices to all qualified employees at the beginning of the year and count that as mandatory notices whether or not they request FMLA?
No. You give them the policy. The policy, you give them the notice, you post you post the FMLA notice wherever you post things. If you've got a person, one person in Wisconsin who's covered by Wisconsin law, where do you post that? They're working out of their home. You tell them, you have to take this to your bathroom mirror. You give them that notice. You just give them a stack of notices that are applicable to them. Have them sign off on it. You give them an FMLA policy in the handbook, and you have them sign off that they got that. But that's a 5-page policy if you cover all the picky little things that you're required to cover. And you should expect that people, especially when they are in emergency situations or have dire medical needs, are not, the first thing in their mind is they're not going to read the policy. You refer them to the policy. The fact that you gave it out is a huge protection for you, but you still need to wait until there's a circumstance, and you expect that people, having gotten the policy and the notices, will understand there is FMLA and they will apply for it. But just because somebody doesn't, you can't say, well, we gave them the notice, we're just going to sit back, because you're the professional. So you need to reach out to them and say, hey, there's a reason you're off. Is this for FMLA? Take a look at your policy. Here's FMLA information. If it does qualify, please fill out the form and let us know, and we'll work with you.
Well, that's all the time that we have. Thank you to everybody for your active participation in our webinar today. And thank you again to Bob for joining us. And we hope to see everybody next time.
And let me say that I've mentioned a couple of articles. If anybody wants those on personal liability, the off the clock that's still on the hook for liability, and there's one other I just mentioned and I can't remember which. Please contact me, but tell me I want the article on, because if you just say, please send me the articles, I will have forgotten. I'll have no clue which article. So give me a hint, and then I will promptly get it to you. Thank you.
Thank you, everybody.